It is gearing up. Okay. I see Miss Salcido is there. Okay. All right, Miss Salcido, can you hear me now, ma'am?
Yes, yes, sir.
Okay, thank you, ma'am. All right, we're going to go ahead and put this matter on the record so we can get get this matter resolved today.
Okay.
All right, the court is calling cause number 2006 AG 2611. This is a hearing on a motion filed by the Attorney General's office entitled a motion to modify and to confirm child support arrearage. The parties in this case are David Treviso and Mireya Salcido. Uh, this matter is scheduled for a final hearing today, March 6th at 8 o'clock. It is now 8:40. Mr. Present. The return on file indicates that he was served with citation back in November 18th of last year, 2020, at some facility of the Texas Department of Corrections. Mr. Treviso is not present, and there appears to be no response filed by Mr. Treviso. My name is Antonio Rodriguez. I am the Associate Judge for the Title 4D Court here in El Paso, Texas. And we're doing this hearing on a Zoom application since we cannot appear in court due to the current pandemic crisis that's going on in our community. However, the Supreme Court of the State of Texas, the Office of Court Administration, Council of Judges here in El Paso have permitted us to conduct our hearings remotely, and we're doing so on this Zoom application. In order to comply with the Texas rules of civil procedure, Texas rules, we have this matter is being live streamed on the YouTube channel. That is to comply with the rules that we have to keep our courts open to the public. As soon as this hearing is completed, however, this live stream will be taken off the YouTube channel. I'm also recording the evidence on the computer generated system, and that is the official record of the proceedings here today. No person is permitted or authorized to record anything that may be in this hearing here today. We are in court. Now I would ask parties to conduct them if they were in court. Also, sometimes the audio portion doesn't work as well as it normally should. So if people are talking at the same time, sometimes the audio portion may not work. Okay, with all that being said, then this indicated this is a motion to modify and confirm. And then we have announcement from the state. Ready to proceed, Ms. Edwards?
Yes, Elizabeth Edwards, ready for the state. The state ready to proceed.
All right, and Ms. Salcido, are you ready to proceed today, ma'am?
Yes, I am.
All right, very well. Let me have you raise your right hand, Ms. Salcido, so I can swear you in. Do you swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. All right, thank you. You may lower your hand now. Okay, Ms. Edwards, go ahead.
Thank you. The state would like to call Ms. Mireya Salcido at this time.
Okay.
Ms. Salcido, you are the mother of the child, Aaron Orozco. Is that correct?
Yes, that's correct.
Okay. And how old is Aaron?
Aaron's 16.
And back in 2016, Mr. Treviso was ordered to pay you child support in the amount of $177 a month and medical in the amount of $38 a month. Is that correct?
That's correct.
Okay. I'd like to ask the court to take judicial notice of the prior order in this case, which was signed in August of 2006, in which child support was ordered in the amount of $177 and medical in the amount of $38.
All right, the court has reviewed the Odyssey system, and I do see that there is an order obligating Mr. Treviso to pay child support in the amounts as testified. That order is in the court file, and it does appear to be in proper form. So I will take judicial notice of the prior order in this case. All right, go ahead, Ms. Edwards.
And Ms. Salcido, Mr. Treviso is not here today on the Zoom. Is that correct?
That's correct.
And do you know where he is currently located?
The last time I heard was that he was incarcerated. I do not know the specific location, but yes.
Okay. And Your Honor, I have confirmed on the TDCJ information site that Mr. Treviso is incarcerated at this time in the Cofield unit, and that his projected release is 2022, and that his maximum sentence date was 2028. And so at this time, he is still incarcerated for a period of over 90 days.
All right. I will take judicial notice of the incarceration, and further the return that is on file does indicate that he was served at some facility of the Texas Department of Corrections. So I'll take judicial notice of the return of service that's been on file for more than 10 days. It actually was served back in November. Right, go ahead, Ms. Edwards.
And Ms. Salcido, as the end of February, so February 28th, 2021, there is an arrears of child support in the amount of $45,070.64, and in medical in the amount of $6,254.84. To your knowledge, is that a true and accurate depiction of the arrearage?
Yes, ma'am.
And I'm going to set Mr. Treviso up on a payment of $200 a month in child support and $50 a month in medical support to begin on April 1st, 2021. Would that be agreeable to you?
Yes.
And once this order is completed, are you okay to receive a signed copy from the court?
Yes, ma'am.
I have no further questions for this witness, Your Honor.
Okay. How about the modification, Ms. Edwards, on child support and medical support?
We would ask that the court modify child support and medical support to 0 at this time due to the incarceration of Mr. Treviso.
Okay. All right, Ms. Salcido, understand that due to his current incarceration and under the Texas Family Code currently, as it currently exists, anybody who's incarcerated for more than 90 days under the law, we have to modify child support to be 0 for the time being, and also medical support 0 for the time being. Now, at such time as Mr. Treviso is released from custody, the AG at that time can go ahead and file a motion to modify the child support, and we can set both child support and medical support. Okay, we're doing that under what the current law is to modify the obligation to 0 for the time being. However, I will go ahead and confirm the child support and medical support arrears and set payments on those judgments. That would be commencing on April 1, Ms. Edwards?
Yes, Your Honor.
Okay. And, all right, is there anything else that we need to address that I haven't ruled upon, Ms. Edwards?
Nothing further, Your Honor.
All right. All right, then, Ms. Edwards will go ahead and prepare the order, Ms. Salcido. She will send it to me through what we call a DocuSign application. Once I do receive it, I will sign it. The order will then be filed with the clerk's office and copies will be sent to the parties.
Okay.
Do you have any questions, Ms. Salcido?
Not at this time. Thank you, Your Honor.
Thank you, ma'am. All right. All right. Well, in that case, that concludes our hearing for today. Thank you for your participation today.
Thank you.
That concludes our hearing. Parties are excused. Thank you. Be careful. Be safe out there.
Thank you.
Okay, thank you. All righty. And I see Mr. Knopf was back. There he is.
Yes, Your Honor. After conferring with the parties, an agreed order has been reached. May I have permission to place the agreement on the record?
Okay. Are they going to be joining us? So we can do that?
Yes, let me bring them in from the breakout room.
Okay, let me see if I can, sometimes I can take them out of the breakout room. I don't know. Okay. Main session. Oh, I can't move Mr. Valdez into the main session. All right. Let's see, Ms. Reyes, can you hear me, ma'am?
Yes, I can hear you.
Thank you, ma'am. And Mr. Valdez, can you hear me, sir? I think you need to unmute your device.
Can you hear me, sir?
Yes, sir, and I can hear you. Thank you, sir.
Yes,
All
sir.
right, I understand parties have met with the Assistant Attorney General, Mr. Knopf, and I believe he's going to make an announcement as far as in this. So at this time, I'll ask both parties, Ms. Reyes and Mr. Valdez, if you can raise your right hand so I can swear you both in, please. Do you and each of you solemnly swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yes.
All right, both parties answered in the affirmative. You may lower your hands now. Mr. Knopf, I think, what is the announcement in this case, sir?
After conferring with the parties, the agreement has been reached in all substantive matters before the court.
All right. All right, I'm going to ask Mr. Knopf to recite the agreement, and I'll ask you both if this is what you all have agreed upon. Okay. All right, Mr. Knopf, what is the agreement?
Parties have agreed that Mr. Diego Valdez is the father of Diego Valdez Jr., born in 2011. Parties agree that they should be named the joint managing conservators of this child, with Ms. Reyes as the primary household, and the residence of the child geographically restricted to El Paso or its contiguous counties. Possession access of the child should occur according to the standard possession order, and the child should continue to be covered under the appropriate government health care assistance program. Mr. Valdez should be ordered to pay $57 per month beginning April 1st, 2021 in cash medical support, and $189 per month in child support beginning the same time and continuing until the emancipation of the child. This is factoring in one additional child that Mr. Valdez has to support outside the terms of this court order. Mr. Valdez should be referred to the NCP Choices program to help him find gainful employment. There should be no retroactive child support assessed at this time. Ms. Reyes's contact information should be non-disclosed in the final order of the court. Mr. Valdez has agreed that this order may be directly submitted to the court without need of his signature. I didn't get a chance to discuss with Ms. Reyes if she'd be okay with that as well. With the court's permission, I seek to poll the parties on that question.
Yes, sir, go ahead.
Ms. Reyes, having heard this agreement, are these terms that you can agree to, live with, and abide by?
Yes, I'm okay with that.
If I were to create a draft of this order, would you want a chance to review and sign off on it, or would you be okay with me preparing it and giving it directly to Judge for his signature?
It will be perfect if you do that for me.
Okay, understood. No further questions for this witness.
All right, okay. I just want to be clear, Ms. Reyes, do you want to review the order, or is it okay for Mr. Knopf to submit it to me directly without your?
It's okay. It's okay if he submits it directly to you. He did explain to me as to what was going to happen. So I'm okay with that.
Okay, all right, thank you, ma'am. I just wanted to clear that up. And there's going to be all right. You all heard the agreement that has been recited by the Attorney General. Ms. Reyes, is this your agreement, ma'am?
Yes, sir.
And Mr. Valdez, is this your agreement as well, sir?
Yes, sir.
All right, I know there was one matter that was addressed that Mr. Valdez will be referred to the NCP Choices Program. Mr. Valdez, purpose of that referral, like, is indicated to see if they can assist you. This is a program that's being operated through the Texas Workforce Commission to assist folks trying to get a job through that agency. There is a contact person. Have you provided Mr. Knopf a contact person so that Mr. Valdez can communicate with him?
The state hasn't provided Mr. Valdez with any information. However, we do have his up-to-date contact info, including home address and phone, which we intended to provide to the NCP Choices staff member.
All right, very well. Okay, having heard the parties stipulate on the record with regard to the agreement, the court will approve the agreement. Mr. Knopf will go ahead and prepare the order and send it to me directly so I can review it and sign it. Once I do sign it, it'll be filed with the clerk's office here in El Paso. Copies of the order will then be sent to the parties. Okay. All right, unless there's something else, that concludes our hearing for today. Thank you all very much for your participation today and working this matter out. At this time, I'll conclude the hearing and parties are excused. Thank you all very much. Be careful, be safe out there.
Thank you.
Thank you.